as per the papers that we have already received, is that this matter is not urgent according to the respondent. But nonetheless, we are arguing that this matter is urgent simply because we are having a documentary that must be broadcasted or flighted tomorrow. And that fact that there will be a broadcast tomorrow on the 12th of September, it means that confirmation of an event or a date of saying on the 12th, Netflix will be broadcasting the documentary. It becomes an urgent triggering event. When we have that as an agent triggering event, we cannot wait any longer to have this matter heard at any other time. And having said that, I will want to bring the court to the attention of a case of Luna Miebel, BPK. This case has decided has laid down the principle on Rule 12, subsection 6, whereby it stated that for agency to be, there are two things that need to happen. Number one is that the circumstances of the case justify the shortening of times and the non-conformity from the rule. Number two is that if a matter is not heard urgently, that the applicant will not be afforded substantial redress at a later stage. The first thing that I want to talk about is that we requested the shortening of the time, simply because should we wait any longer for this documentary to be flighted or broadcasted, we then have a situation of saying the impact that it would have made, it will not be reversed or anyhow amended. That's why we requested that this matter be heard on urgent basis. Then number two, we are dealing with the issue of substantial redress at a later stage. On our part A, we are arguing to say, should this Netflix documentary be broadcasted, my lady, how will Mr. Bester be afforded any substantial redress when this very documentary, seemingly it has got impact on his trial, which is pending?
Well, the magical word you used is seemingly.
It will have. Remember, I'm saying seemingly because we don't have the full, we don't know what is contained fully in the whole documentary. We are talking about the trail of almost 30 seconds or so that has been exposed to us. So according to the trail that has been exposed to us, there is so much that seemed to have an impact on him. Even on that shortest 30 seconds, we have a lot that we can say, these are some of the words that are said that will have impact on the trial of Mr. Thabo Bester. And I will come to the merits and explain some of the things that I'm speaking about from the trailer. So now, on the issue of urgency, we cannot wait for any, we do not have any substantial redress at a later stage. The only substantial redress that we can have now is to say, we can only have it now to say, let this documentary be interdicted not to be flighted tomorrow, not to be broadcasted tomorrow. Why? Because the moment it's broadcasted, whatever that is in there, it is most definitely going to affect our client trial, which is pending at the moment. And also, I have one interesting case of Mogalakwena Local Municipality versus Provincial Executive Council, where Judge Tuchen stated in paragraph 64 that it seems to me that when agency is an issue, the primary investigation should be to determine whether the applicant will be afforded substantial redress at hearing in due course. If the applicant cannot establish prejudice in this sense, the application cannot be urgent. Once such prejudice is established, other factors come into consideration. I want to emphasize the aspect of prejudice, to say here we are having an urgent matter because there is a prejudice that the applicant, Mr. Thabo Bester, will suffer. What prejudice are we talking about? Number one, we are referring to the right to a fair trial, Section 35(3) of the Constitution of the Republic of South Africa, Act 108 of 1996. Now, we are also referring to the right to human dignity, which is in Section 10 of the very Constitution I mentioned. And we are also referring to Section 35(3), which is the right to be presumed innocent until proven guilty. Now, when you look at the trailer of the documentary that Netflix want to broadcast, there is so much that leaves, that is left undesired for our client, Mr. Thabo Bester. Why? Because there is somewhere there where it is stated, one of the speakers in the documentary state that Mr. Bester faked his death and escaped from prison, not allegedly. He speaks it as though it's the gospel truth, as though it's absolute, he has got the factual proof to say indeed he faked his death and escaped. And these are the allegations before court. It has never been established, he has never been found guilty at any point. We also have got a challenge with the trailer itself, because we have in the trailer, number one of the co-accused, which is the father of the second applicant, Nandi Magudumana. What challenge are we having there? There is a phrase that the father of Nandi Magudumana says. He says, "I cannot imagine my daughter doing such a thing." The question is, what a thing?
And how does that reflect on Mr. Bester?
We are coming to that. We are coming to that. Then we have an issue of saying, what is such a thing? Definitely when we speak of such a thing, which the trailer has already suggested, where one of the speakers says, we don't know whether Dr. Magudumana is an accomplice or a victim. Now, accomplice to what? To Mr. Bester, whom already the trailer has rendered him to have faked his death and escaped from the prison, which is not allegedly, it is stated like that. And I would also want to direct the court to the answering, I think the answering affidavit of the respondent, Netflix. There are some interesting things that are being said there that that the court really need to look at them in order for us to be able to find a way forward. When you read the answering affidavit, it's kind of unclear what are they saying about this this documentary. Somewhere there on, let me quickly look at that. Somewhere there on their papers, they say Mr. Best. This documentary is not about Mr. Best. It's not about Mr. Thabo Bester. They state it, but somewhere there, they simply state it clear that it's about Mr. Bester, and then still that is what the court needs to look into. In paragraph 28. In paragraph 28 of the answering affidavit, it says, at paragraph 46 of the funding, Mr. Bester alleges that Netflix is exploiting his life story for financial gain without consent, which seems to be a repetition of his personality rights argument. As indicated above, this rejected. There is no exploitation of Mr. Bester's life story. The documentary focuses on the prison and criminal justice system, as well as broader societal issues about social media, gender-based violence, public safety. This is not Mr. Bester's life story. It is proven this will be a private law claim and remedial through damages. So now they say the documentary is not Mr. Bester's life story on paragraph 28. And I want the court to also look at paragraph 9 of the answering affidavit again. It says on paragraph 9, the Beauty and Bester, which is the subject of this application, is similarly a true crime documentary. True crime documentary. It profiles one of the most notorious events in South Africa's recent criminal justice history, the escape from prison of Mr. Bester. The escape from prison of Mr. Bester, who is convicted murderer and rapist. His relationship with famous and glamorous medical doctor, Dr. Nandi Magudumana. It is this documentary which Mr. Bester does not want Netflix viewers to see. The documentary was produced by a company trading, this part is not important for my argument. The most important part is that they say this is not about the life story of Mr. Bester. Now here they come on paragraph 9. that this is about the escape from prison of Mr. Bester. Escape from prison. The problem is this. We said we are arguing on section 35, subsection 3 of the Constitution, whereby everybody has got a right to be proven innocent. Everybody has a right to be declared innocent until proven guilty. Now here we have a situation of saying the Netflix, it is putting it as a confirmation, as if there is a judgment that Mr. Bester has escaped from prison. And there has never been any proof that says he has escaped from prison. He has never been convicted on that. And that is what the court needs to look into when it look into this, this documentary. And also on that, speaking about the documentary, there is a very interesting aspect that turns this documentary not into a social commentary. It turns it into some sort of a kangaroo court, or a quasi-court, or a moot court, whatever kind of a court we can call it. Because somewhere there is one of the most respected legal person in this country, Judge Cameron. Judge Cameron...
Are you saying Judge Cameron is the head of a kangaroo court?
I'm not saying he's the head of the kangaroo court. I will not even dare to say that he's the most senior. I have to give him so much respect. I'm saying this documentary becomes some kind of... I have never impliedly said that, and I will never say that. And I'm not even creating that impression to the court.
Well,
what I'm saying to the court is...
Yes?
Permit me to answer, and I will finish my statement. What I'm saying to the court is, we are having Judge Cameron featured in the documentary. The first thing that he says, which is just a line in opening, he says, this is the most improbable thing that I've ever seen as a judge and in my life. Now, Judge Cameron is speaking as a judge and also in his personal life. He is not just there as a commentator. He is there as a judge, and he acknowledges his position. He says, as a judge. And I am saying, or rather we are saying in our application, such makes this whole documentary to take a different turn, because the moment a former judge who has done so much work, we read so much of his precedents. I have so much respect of Judge Cameron. And I'm saying, him speaking there, talking about this as one of the most shocking stories of his life, it then creates a certain element in this documentary to say, it seems like Mr. Thabo Bester, who is fully a center of this documentary, is already found guilty in a documentary. And why am I saying this documentary is still about Mr. Bester? Because they say the beauty and the Bester. Who is Bester? Is Thabo Bester. Now, we know the phrase Beauty and the Beast from one of the old movies. Now, the Beast no longer exists. Who exists? The Beast has been replaced by Bester. So it means that in the nearer future, we are likely to have a situation whereby when kids are asked, what do you know? They won't say the Beauty and the Beast as we knew in the literature of English ourselves, who grew up during that time. They will say the Beauty and the Bester, meaning that the beast has been replaced by a certain individual. Now we have a beast in person and personified into the person of Thabo Bester. So then this documentary, from its naming angle and perspective, it has already brought what we call a serious defamation to the person of Thabo Bester. And we cannot sit and keep quiet when Thabo Bester, who is my client and the applicant in this matter, is being termed or rather narrated as the beast. Because that's what the documentary suggests. Proceeding on engaging the answering affidavit, my lady. I have there is something here that is very interesting. On paragraph 27. On paragraph 27 of the answering affidavit of the respondent.
Can you refer me to the page, please?
Let me ask my colleague here for a page. Thank you. My colleague just assisted me. He says it's 137 or 00005-137. Apologies for the delay, my lady.
Thank you.
I am reading from the hard copies. I'm still functioning like an old lawyer, even though I'm young.
Yes, I'm ready.
As I proceed on paragraph 27. At paragraph 28 and 29 of the founding affidavit, Mr. Bester alleges unlawful exploitation of his personality rights. There is no exploitation of Mr. Bester's personality rights. A documentary about an alleged escape from one of the most secure prisons in South Africa is clearly in the public interest. Moreover, this documentary deals with broader issues of global significance, including social media, gender-based violence, public safety. Netflix is entitled to commission such documentary. If there is a course of action based on this, it can be addressed later in civil action. For now, the public is entitled to make up its mind about the present system is alleged to have allowed a convicted man to escape from a maximum security prison. Now, reading paragraph 27, it creates an impression of saying, this documentary will simply come and say, we have done our research, we have the fact, we have found the truth, Mr. Bester has escaped. But there is no court that has declared, that has made a judgment on that. And if they say the public is entitled to make up its mind about how prison system is alleged to have allowed a convicted man to escape from a maximum prison, a convicted man has escaped from a maximum prison, they are already creating an impression of saying he must be found guilty. And that's where now we are talking about a fair trial right being eroded or violated. And also, my lady, I want you to also look at something that is very interesting here on the very same answering affidavit. On the very same answering affidavit. On paragraph 40 of the answering affidavit, it says, I hope the page will not be a problem this time. On paragraph 40 of the answering affidavit, it says, Mr. Bester's allegation about consent, participation and approval rights are thus both factual, inaccurate, and legally irrelevant to the relief sought. There is simply no basis upon which a notorious public figure, such as Mr. Bester, can seek censor to censor speech about him, simply because he has not given consent. If this were the law, no speech about public official or public figure will be permissible absent permissible absent their consent. Now, I want to direct the court specifically to this phrase that says there is no simply basis upon which a notorious public figure, such as Mr. Bester, can seek to censor speech about simply because he has not given consent. Now, because there is Mr. Bester who is purported notorious, and this has to be questioned, how do we conclude that somebody is notorious? Is there a measure that Netflix uses to declare somebody notorious? What do we have 1 to 10 to say Mr. Bester is notorious? When you cross the bar of 8 allegations, so you say that's where you are notorious. Or how did they conclude that he's notorious? And having said that, they still come to say there is no way he should consent. It means that now the right to dignity of Mr. Bester is in question. He has no rights anymore. He can be spoken about as if it's just a piece of meat that has no feelings, emotions, or mind. Then that's where the court needs to look into this documentary as a violation and erosion of human rights. Because if Mr. Bester is notorious and we can talk about him anyhow and have people speaking there and declaring him guilty as if they've got all the facts right and the court has backed their claims, then we are having a challenge in South Africa when it comes to protecting human rights. And also, I want to bring a very interesting point in this, to say, you know, the way this documentary has been sensationalized and the vibrations of it, including the emotions created. There is one speaker on that documentary says, "Are you dangerous?" And they They edited it, putting Mr. Best on the other side, saying, yeah, as if he's answering that question that he is dangerous. Now, that is manipulation. That is artistic manipulation. Very wicked craftiness of the editors of this documentary. Because they are sitting there, putting stories as if he is confirming that indeed he is a dangerous man.
Where is this in your papers?
It's there in our papers. In my funding papers, it's there. It's there in my papers. Everything I'm saying is in my papers. I will not waste court time and speak from my mind.
I'm asking you a question, you can just answer it.
It's in our, actually, it's in our replying affidavit. It's in our replying affidavit.
Yes, because it definitely wasn't in your founding, so it's something new.
Yes, it's. My lady, I didn't get that one. Can you please repeat that?
I said it wasn't in your founding affidavit, so it's something new in your replying affidavit. Where is it in your replying affidavit?
Actually, in our funding affidavit, we do explain about the manipulative editing that this documentary has. And on our replying, we were expounding on that. Actually, our replying, we were adding more meat to what already is being raised in the answering affidavit.
So where is this about Mr. Bester, and then as though he answers yes, he's dangerous?
I'm trying to get the paragraph of, the actual paragraph where this is being actually said. My lady, on paragraph 31.
Are we in the founding or replying?
Is on my replying.
Okay.
Is on my replying on paragraph 31. On paragraph 31. Excuse me, my lady. It reads thus: as argued in my funding affidavit and elsewhere in this affidavit, Netflix has employed crafty and manipulative editing practices in the publication of this documentary, which can also be seen in the trailer, where one of the commentators is shown to be asking the question, will you say you are a danger to society? And a video clip of myself is then superimposed after stating something along the lines of, yes, I will say so, or yes, I believe so.
Thank you.
So we have that in our papers. So now this also shows that this documentary simply tries to drive a certain narrative about Mr. Thabo Bester. And then now, if we have this kind of a documentary being flighted, whereas on the 19th of September, next week, Friday, he will be appearing in court, what is the impression that is being created there? And also, these are type of documentaries that make the public to believe that somebody is guilty. When they are not found guilty, then the judicial will be looked at with wrong eyes or will have a bad reputation, simply because there were some prominent people, celebrities, who were speaking, social commentators, that he is guilty. And this is so emotionally created that it becomes one of the greatest assets of manipulation that you look into this documentary. I saw one of the celebrities, well-known figure, crying. I wonder, why is she crying? What does she know? Was she there? So these are some of the questions that we really look into. And also, one of the impressions that Netflix or the Respondent is creating is to say they are listing a number of articles that have been written about Mr. Thabo Bester. To say it has been written about his rape cases, his Facebook, whatever. They bring many articles that they Googled and they printed them and brought them to court. Now, my question is that because there has been so much published unfounded without having the actual proof of that, should we allow the further publication on that? Is that how things must be? Because some articles have been written in some newspapers, some video clips have been made on social media. Must we allow also Netflix to do the same? And Netflix has already described itself as one of the giant media houses that says it has got 300 million, how many? 300 million subscribers or viewers. Now, if Netflix published this tomorrow, this documentary tomorrow, just for 1 hour, with their 6-point-something million followers in South Africa, it means that in a space of 1 hour, after this radical marketing that they have undertook with this trailer and this documentary through the trailer, it means that we are going to have many people seeing this, and after to see this, a public opinion and the public court would have decided otherwise about Mr. Thabo Bester. Then when that has happened, the question I'm having is this: are we still gonna have are we still gonna have a fair trial in that regard?
Sorry, are you saying that a documentary will influence the court, a judge?
I'm saying,
because I find that quite preposterous. Because let's just take it to the end. A judge can only make a finding on the evidence that's before him, and it can definitely not be on a documentary.
I am saying a right. What I'm saying, which is in my papers, I'm saying a right to be presumed innocent until proven guilty, which is section 35, subsection 3 of the Constitution, needs to be protected. This documentary, I'm answering your question. Allow me a space to elaborate my answer. I will answer you fully, my lady. I am saying section 35, subsection 3 of the Constitution, a right to be presumed innocent until proven guilty, has to be protected, including even with a notorious person as labeled by the respondent, like Thabo Bester. Why? Because should that be, when he is found guilty, we do not know what influence will that be. We don't know the amount of influence will that documentary be having in that proceeding. And we are saying such documentaries carry a weight into the public court, carry a weight into the public opinion and interest of the people. And also, my lady, hear my argument within the context of everything that I've been saying for past 30 minutes or so. I have already said, in this documentary, we have the accused, one of the co-accused, who is speaking, the father of Magudumana. I'm repeating that. And she says, I could not imagine my daughter doing such a thing. It's left there so that people can go and watch the documentary to hear what such a thing will my daughter be doing. And now we also have a judge, Justice Cameron, speaking in that documentary, saying, as a judge, I have never seen such a thing. What a thing is that? Definitely we are talking about Thabo Bester's alleged escape. which already the answering affidavit have stated that this documentary is about that. Now, my argument says, when such documentary are flighted or broadcasted, we then are standing in one corner of the truth, because he is also not given a right of reply. But that is not part of this argument. It's part B of the argument. I'm just saying it in passing, because it has to balance my argument. Part B has to balance my argument in part A. So, the court finding him guilty or not finding him guilty, the moment he goes on the street and is not found guilty, because I believe that he's hiring lawyers like us so that he should not be found guilty. He will not be found guilty, I suppose. Then the state has failed to prove his case beyond reasonable doubt. Now, already the documentary has stated some kind of their truth or some kind of their baseless facts to say he has escaped. Now, it means the judiciary of South Africa allows somebody to walk free who has been found guilty by the public opinion. I am addressing the public opinion, and I'm speaking about the fair trial here. And I'm speaking about the right to be presumed innocent until proven guilty. And that cannot be left unattended. Now, having argued all this, my lady, the question is, why are you in court and sweating so much, Advocate Maila? The reason we are in court is because we are asking that this documentary should be interdicted. On which base do you want this documentary to be interdicted? There is a case, as I'm closing, there is a case of Setlogelo versus Setlogelo, which is there on my practice notes. The case has laid down very important requirements for an interim interdict. Number one, it stated that a prima facie right, though open, what is required for an interim interdict to be granted by the court? Number one, a prima facie right, though open to some doubt. That's number one. Number two, a well-grounded apprehension of irreparable harm if the interim relief is not granted. Number two, the absence of an adequate alternative remedy. The absence of an adequate alternative remedy. Number four, the balance of convenience favor the grant of the relief. Number five, the balance of convenience favor the grant of relief. Then the last one, oh, this is me reasoning. This is the fifth one will be the balance of convenience favors the grant of relief. Now, my lady, when you look, when you look at our founding affidavit, the applicant has covered all the requirements set out in Setlogelo case. Number one, prima facie right, you have already stated that there is a right to fair trial, which is section 35 of the Constitution. A right to be presumed innocent until proven guilty, which is section 35(3) of the Constitution. And also a right to dignity, which is section 10. A right to equality, which is section 9. And also number two, a well-grounded apprehension of irreparable harm if the interim relief is not granted. There is a phrase we use there to say once the bell is rung and the documentary is flighted, what then will be of Mr. Bester? And people have seen the story, have heard whatever that has been heard. What more will be? Obviously, there will be irreparable harm. After the documentary has played for 1 hour or 2 hours, since they said it's 3 parts, after the first part, they are done with Mr. Bester. He's already guilty by the format of the trailer. Number three, the absence of adequate alternative remedy. If this documentary of Netflix is not interdicted, my lady, what more will remedy be for him after it has been flighted or broadcasted to 300 million followers of Netflix in 160 countries as they boast? Definitely, Mr. Bester, in every corner of this world or planet Earth, he will be known as a man who faked his death and escaped, because we saw it in the trailer. It's there. And number four, the balance of convenience favors the grant of the relief. I mean, when you read what the respondent says in their papers, they say the reason this has to be played or flighted is because they cannot keep their their followers or subscribers in suspense, meaning their subscribers are more important than the human rights of Mr. Bester. Their intellectual or emotional tickling and their feelings must be created at the expense of Mr. Bester's rights. Now we also have we also have the convenience that the convenience favor the grant of the relief. What more will be convenient for the court except to order an interim an interim interdict? I do not see any possible way except this. And the court must note in our papers, we do not say this must not be unpublished. We say let the trial end, and they will publish it, whether he's found guilty or not. They will even have more because it will have even the trial in it. It will even have this part. So they will have a bigger meat to give to their 300 million subscribers. So now, my lady, I also want to conclude on this case that deals with the specific requirement for prohibition of media broadcast. It's coming from the case of Media Television versus Director of Public Prosecution, which the respondent has labored very hard on it. Here, the Supreme Court of Appeal was asked to prohibit the broadcast of a documentary on the grounds that it might prejudice a pending criminal trial. The Honorable Judge Nugent held that the publication may be prohibited where a prejudice it might cause, one, a demonstrable and substantial harm. Number two, where there is a risk that the prejudice will occur. Number three, that the disadvantage of curtailing the free flow of information outweighs the benefit of preventing the prejudice. Now, looking into what the Media Television case has brought, we are sitting now, my lady, on an argument of saying, does Mr. Bester has a case that can be decided in line of Media Television case? Indeed, you look at number one, that a prejudice is demonstrable and substantial. My lady, if one of the accused, father and also the co-accused, and the father of one of the accused says, I could not imagine my daughter doing such a thing. What a thing. I'm wondering what a thing is there. Definitely he's not talking about her daughter graduating to be a medical doctor. Most definitely he's talking about assisting or doing whatever in this alleged escape of Mr. Bester. Definitely it's about that. And number two, we are talking about, the case says there is a real risk that prejudice will occur. Once this documentary is flighted, prejudice will occur. What prejudice is that? We can mention close to 20, but for now, I will say to save time, let's mention 2 or 3. Number one, we have 300 million subscribers who will be listening to people declaring a man whom the court has not declared guilty to be guilty, who are sure of what they do not know. That contradiction there, they are sure of what they do not know, as if they were there when they saw him escape from a prison. We have that problem now. And we cannot allow that to be flighted because there is a trial coming. Let the trial decide. After the trial to decide, that will happen. And my lady, this is not the first documentary, by the way. We have documentary of many celebrities with their trials, including your Oscar Pistorius, including your Mudimulle, Monster. All of this documentary after the trial. Why is this one supposed to come up now? Now, number 3, the disadvantage of curtailing the free flow of information outweighs the benefit of preventing the prejudice. Now, there is an argument of saying we are affecting the freedom of expression of Netflix. But the truth of the matter is that we are not. Because this documentary is their investment, they have made it with their money. They can still archive it and do more parts, play it later. It will still be there in their archives. That is their intellectual property right or their right to creative work. So we do not what we are not doing this application to curtail the free flow of information. Perhaps at the time when they do this, Mr. Bester will be granted a right to reply. So, my lady, having said that, this brings me to the conclusion of my argument to say, if there is one thing that I will argue the court should do, is to simply grant an interim interdict of this documentary. Allow the court to make a decision on Mr. Bester's case, looking into the constitutional right of Mr. Bester. Number one, a right to be presumed innocent until proven guilty. Number two, a right to a fair trial. Number three, a right to dignity. Number four, a right to equality and protection of the law equally. Having said that, I thank you, my lady.
Thank you very much.